5 patent myths demystified. Number 1, provisional patent is good enough for now. Number 2, I can get worldwide patent rights. Number 3, I can patent an idea I don't know how to make. Number 4, I can decide who I want to be named as an inventor. And number 5, everything shown in a patent is patented. So, number 1, provisional patent is good enough for now. That sounds great, but there is no such thing as a provisional patent, even though that term is very often used. It's not a patent, it's a patent application, and really it's hardly even that. A provisional patent application is a priority document. It will never be examined, it will never become a patent. It serves to support, to maintain that priority date, which is really important because that's what determines what is prior art to you and what you are prior art to. So it does have a really important function, but it is not, it will never become a patent, and that function is really only delivered if sometime during that year before it expires, you file a non-provisional claiming priority to that provisional. So again, no such thing as a provisional patent, so it is not a substitute for a non-provisional patent application or a patent. Number 2, I can get worldwide patent rights. There is an organization called the World Intellectual Property Organization, so it sounds like you can get a worldwide patent, but you can't. At least in 2025, when I'm recording this, we are still a world made up of nations that have boundaries and each have their own laws, and the patent laws of each country they last to the boundaries of that country. They're enforceable within the country, but not outside the country. So they each have their own slight variation of patent laws. So what WIPO does, which is really useful, is they do administer and manage this process for the Patent Cooperation Treaty, or PCT, which allows you to take a U.S. patent application and in a streamlined way apply for patent rights in different countries. It's a really excellent process. It saves you a lot in legal fees, but you still aren't going to be getting patents in every single country that is a member of the PCT. You want to be selective and choose the countries that actually have value to you. So that's number 2. There is no such thing as a worldwide patent. Number 3, I can patent an idea I don't know how to make. If it's very often, especially with software, where you might have a great idea, but because you're not a software developer or someone with expertise in some particular industry, plastics or who knows, you don't know how to actually make, turn your idea into something that would work. You're not quite sure how to make it work. So in those cases, you'll have no trouble finding companies that will take your money and give you something called a patent application. The problem is that it won't do anything for you. It won't. There isn't anything patentable until you know at least something about how it works, how to make it work, how to build it, how to make it work. Because number 1, abstract ideas are not patent eligible. So if all you have is an idea, it's not patentable. Number 2, in order to get a patent, you have to be able to explain it. It has to be enabled. You have to be able to explain how to build it, how to make it work. That's just right in the patent rules. So be careful, and my recommendation is that you bring someone in. Either you pay them, of course, make sure that you protect yourself with contracts. Either pay them to do the technical part for you so that you can pursue a patent, or bring them into the company, give them some ownership if you find someone you trust. Again, protect yourself with contracts. But you will need that technical part worked out before you can apply for a patent or even do a patent search. Otherwise, you're just wasting your money. So that's number 3. You can't get a patent on an idea that you don't know how to make. Number 4, I can decide who I want to be the inventor. Inventors, I can decide who I want to name as inventors. You can, of course, but the problem is that there's actually a legal definition of who is an inventor. It has to be someone who contributes substance to something that makes it into a granted claims. And at the end of the day, what that means is if your daughter or son are an amazing artist and you're using them to draw some things to do your sketches maybe for your patent application, that doesn't make them an inventor unless they're actually inventing with you. The downside of naming people who aren't really inventors, it's a very nice thought, but the downside is that that could become something that's used by opposing counsel if you ever need to enforce your patent application, your patent. They can, if they find out that there are people named who aren't really legally defined, don't meet that definition of inventor, they can claim fraud on the patent office and your patent could be invalidated. It's just not worth the risk, in my opinion. Make sure that you name the people that actually are inventors. And by the way, if you don't want them owning anything, then get them to assign their rights to you or your company. That's completely fine, but you still have to name them as inventors. They are still inventors. Number 5, everything shown in a patent is patented. This is one of my favorites, especially journalists, and a lot of people get outraged when they see a patent, one of the big, Google or Apple, and they say, I can't believe that they've patented this thing. They're looking at the drawings maybe or reading the verbiage and saying, that shouldn't be patented. We've already known about that. Well, the drawings and the words, most of the words of the patent are not what's patented. They're what's disclosed. What's actually patented is the numbered claims at the end. So this is a really important distinction, and I think will surprise a lot of you. But really, I encourage you to look at these patents and look at the words of the granted claims. That's what's actually covered. That's what is patented. All the rest is just support and disclosure. Important, but not patented subject matter. So I hope that was helpful. It's Catherine Cavella, IP Works Law. I'll see you next time.